Let's go. Right. So, okay. With regards to suspect A, she says suspect A was in his 20s, dark skin, brown, dark skin, brown, gold. Let us gold tooth was cane, and a brown jacket with collar, and suspect B. She wasn't able to describe suspect B. Uzandi, suspect A, same as Kelly, in his 20s, not 25 years. It was in his 20s. Kelinda is lying. Okay, no. Kelinda is not lying. I'm going to come to Makaleni. Kelinda is not lying. My apologies. Okay, Uzandi described as what Kelly said, suspect A, and Uzandi, suspect B, she was unable to see. Utumelo, same as Kelly and Zali, that's how they described. Suspect B, they were not able to describe suspect B. So you've got Kelly, Zali, Tumelo, they can't identify this person. Utwala, he was unable to give any description. Now let's come to Makaleni. Makaleni, he doesn't talk about suspect A. Makaleni talks about suspect B. Suspect B, black, the age is 25, the age is plus or minus 25 years, 1.8 meter, slender build, leg holding, gold tooth, with dreadlocks, and he had a gun. Let me repeat. Makaleni is what he said. Two scalar, not home statement. Two scalar, and according to this law, it is AI. The statement of Steenkamp is a hearsay, because this is what she was told. It's a hearsay statement. Now, because even Ginida's statement in terms of him as an IO, it's same as Steenkamp, it's a hearsay. Urat has said that in court. What Ginida's reading is a hearsay, not what he actually experienced. But let me repeat what Makaleni said. Makaleni could not identify suspect A. Let me repeat. Makaleni could Steenkamp evidence. He could not identify, or he was unable to identify suspect A. However, suspect B, this is what Makaleni said. Black is black, 25 years of age, 1.8 meter, slender in build, black holding, gold tooth, with dreadlocks, and he had a gun. I'll stop there.
Thanks, Timo. Do you have what we wanted to hear also is the part where, if it happened, because I can't remember, if it happened that Ramsipili read Steenkamp's statement, that's what we want to hear in terms of what was said.
Steve, do you have the dates there? Yeah, I was coming there. Just to settle this matter, go to the 28th October 2020. 28th October, and Google it there. Just Google there. When Ramsipili, 20. What am I writing? What have I done now?
Is it 24?
No, it will be 2020. 2025. What the heck? Why?
Who can in that play?
No.
What year are we on right now?
No, let it guys. Excuse me. Lena Jam. I'm asking for that now. 20. I am perfectly calling. I know. The thing no, put it in your thing. I put it in. I know.
Shiva, I'm here to ask a question. I grew up now back in the day. Mashiva.
Yeah, 28 October 2024, Malo is just leading the evidence. There's no cross-examination. So it should be another day. Yes. I told you, don't come with this age thing on the panel.
I got a call.
No, I'm saying don't come with this age name on the panel. Now when I say honey, my wife will think I'm cheating on her.
I wanna change my name soon.
Don't play, but continue. What's the question?
I have a question.
Yeah.
What?
Okay.
Let's say Statement Samakalin was introduced by whoever. It's ended up Umarat is going to use it. What does this have to do with Makisa and Section 174? Because maybe I'm struggling. Because there's something that confirms sometimes you say, I don't know. What does this have to do with Section 174? Why bring it now? That's my question.
I think Fika came at the right time.
Okay.
Did you hear the question? How are you, sir?
Good, and you?
Good, man. Did you hear the question from this
Joy.
lady who's calling herself honey?
Yeah, I heard the question. Perhaps if I can start by greeting everybody on the panel, also on comment section. Network is not good these days.
Yeah.
But if I may start a little bit back, when if hearsay evidence, especially a statement of a dead person who is not come and testify, you have to do an application for the statement to be admitted. Submitting statement together with the death certificate. You will call the police officer who took the statement and authenticate the statement to say, this is my signature, this is the certificate that I was told, recorded the story as it is in the statement. And then the statement can be handed in terms of section 3 of the Bill of Evidence Act. And then in this case, I understood when Kubalon was addressing the court about the statement of Makali. He said the statement was not handed in as exhibit, but there is somebody who, upon receiving that information about the statement, made some statement which is having a similar content in that of statement of Makali. And that statement was introduced into the proceedings by the defense. Therefore, they were admitting to the hearsay evidence of Makali, of which, in terms of what I know, it is incorrect. That is how he introduced the statement of Makaleni and hearsay evidence, and saying it defense admitted to the content by introducing the same into the record. That's what he said when he addressed the court.
Yes, are you saying that part is not correct? When it says the defense introduced this, therefore, automatically it turns hearsay evidence into evidence, not hearsay.
No, he is not correct. Statement of Makaleni was not authenticated. The person who took the statement was never called to witness stand. That is why Urata was asking if it was taken by Ukininda. That's why he was asking that, because he somehow wanted to make it admissible. I do not know. But the statement has to be handed to the court, get certificate. The person who took the statement must come to indicate what is contained in the statement. What I was told. The case Kakapa is saying that. The case of Kapa that they are relying on.
That process you just explained needs to happen even if the defense introduced hearsay evidence.
No, it depends. If you introduce hearsay evidence, it's admitting to the hearsay evidence. But in this case, the statement of Makaleni itself was not authenticated. The defense did not introduce statements from Makaleni. They spoke about statements of another police officer who had that Makaleni made statement in this nature, and he made his statement referring to statements of Makaleni. But Makaleni is not admitted.
Steenkamp is the one who says, I was speaking to, in her statement, which was introduced by the defense, Steenkamp says, I was speaking to Makaleni, who was telling me this, and that. Will that be part of hearsay which is admitted because it's introduced by the defense?
Was Steenkamp testifying in court?
He never testified.
No, it's still the hearsay as well. But if it was introduced by the defense to the record, it means the defense was considering that particular portion of Steenkamp is correct, but it doesn't authenticate what Captain heard from Makaleni. The statement of Makaleni itself must be taken into the court. And that's number one. Number two, if the statement Makaleni was introduced by the state, for example, and the defense was objective, at the closure of the state case, the state must apply to the court, as Orams was saying, must apply to the court to say, this kind of evidence, this part of evidence is hearsay, can it be admitted during the state case? Once the case is closed, they can later on revert to it.
And that's what Valerie was trying to do, sleeping in.
They are trying to put hearsay evidence into the record, because now they are referring to the statement of Makaleni, which was not an issue in the proceedings. His evidence is not in record, and the reason for him not to testify is not in record.
I wanted to ask something now, because after you had mentioned that since Mrs. Steenkamp never testified in court, what if now the defense called Mrs. Steenkamp to testify in court, and then that issue comes up from the state, from the defense? I'm sorry, from the defense when they cross-examine to correct evidence in chief with her. Is that
No, I don't think they can call. I don't think they call the witness who will come with hearsay evidence that will kill their case. I don't think they will do that. Hearsay evidence becomes admissible if, for example, you cross-examine a state witness, when as a defense you cross-examine a state witness. So those answers, even if they are hearsay or whatever the case may be, they are admissible because you are the one who is bringing in the hearsay evidence. That is why Ubalo is saying the defense brought in the hearsay evidence. Therefore, that piece of evidence is admissible.
The defense, they will call Steenkamp. And inside Steenkamp's statement, there is parts where Steenkamp is referring to what Makaleni has said. And the state wants to run with that portion of what Makaleni has said to Steenkamp inside Steenkamp's statement. And the defense has introduced Steenkamp, and they said they will call Steenkamp. So can the state now rely on that portion in Steenkamp's evidence, because the defense are going to call it?
At this stage, they can't, she has not, if evidence was admitted provisional, he has not come to confirm the content or what is contained in his statement. It is provisional, it's not yet accepted.
Makes sense.
In as much as confessions are...
Victor, sorry to interject you, but... Can you still hear us?
Yeah, we can. Yeah, Bobs, you seem to have a... Okay. I see Stimo is...
Shava. Oh, sorry, Stimo, 2 seconds. My question. Does this have any... How does this affect... Okay, we hear about the statement. Ram sat there and didn't say anything. So, how does this affect the application to accuse number 4? That's my question.
Okay, honey.
Yes.
Can I try to answer you?
Please.
The state is arguing that
Hearsay, the mini confession of accused number 2, for example, should be a statement that statement, which is called a confession, is actually not a confession per se, but is exactly containing a conspiracy to commit a murder. Therefore, it is admissible as per State versus Mhlongo and Goes. And then they are saying there is other evidence in Lunde which is implicating accused number 4. Therefore, there is case against him to answer because of those particular evidence. They are quoting evidence, for example, like Makaleni. They are quoting evidence, for example, like Zoom, seeing them in hostel. They are quoting my cell phone records as other evidence which implicates accused number 4. Therefore, he has something to answer.
Thank you.
Fihlamusela ngicela ukubuza. So we have those things that were introduced by the judge. Sorry.
You know, raise these hands before even Hani can speak, unless he wants to allow you to ask.
Oh, sorry.
You give permission or you are allowed.
Okay.
My Lord is allowed.
Thank you. So I wanted to understand. There's, for instance, Baloyi in his initial arguments or response to Malo's request or application, he never heard anything about Makeleni. It was added at a later stage after Judge Rata mentioned it. Ne? So in instances like that, like legally, what happens when it comes to such things? Because there's a lot of things that have happened in that courtroom which were not initially thought of, or ideas were given by the judge himself to whether it was a witness or it was Baloyi or Sibanda. It was the judge that initiated a certain narrative, and then that they took that narrative and moved with it. So what happens to that situation of a judge who does that? Because I don't think that can be allowed, or it's legally. What can the defense do when it comes to such situations? Because in this case of Makaleni, it was the judge that brought it up, and then now it is added and it's becoming a bone of contention because of the judge.
Yeah, in case you feel that the judge proceedings were conducted irregular, you can take the matter to review, or you can that can also be the ground of appeal. You can't say at this stage, for example, you can't point the judge with the firearm to say no, you must not do this, you must not do that. But your remedy is to take the matter to the next forum.
Okay, thank you.
Efficacy. Yes. Donsi was here asking about if the councillor is reading a portion of the statement.
Do you allow?
Okay, sorry. I went down, I thought maybe it was that.
Because Timo has raised his hand. He just want to see if he still has a question or you can continue.
Yeah, NoniM, man, just rob me of my question. Yeah. But
Ngiyaxolisa futhi omdala. How Nkosi
no,
yami?
that's fine. It's all in good spirit. Anyway. Fisher, I'm gonna try and remix this one. Hopefully it's gonna come out right. Yeah. What the defense is arguing, the way I understand that corner that one. Umumalo is the one who raised up. I know others they indicated because of 517, but let's speak Umumalo. Accused number 4's lawyer says we want to apply for 174, and we've got point 1 to point 5 of our argument, and that's it.
Correct.
Now, my understanding is that the state is going to come back and respond to 1, 2, 3, 4, 5, and maybe add what they want to add just to supplement everything, right?
Yes.
To make everything comprehensive in terms of their submission. Now, if there's anything outside to these heads of argument between defense and state, like now we are faced with this Makaleni who's surfacing from nowhere.
Yes.
Now, as if you were given a privilege to be in Rata's shoes, as soon as the state is introducing something outside the heads of argument, what is the action there and there that you must take as a child?
Empeleni, what is happening here? The state is trying to see the application if it is part of the evidence during the trial. They are entitled to do so. Say, no, but I'm not going to grant you. For example, this DNA is linking you, even though they did not address him on the DNA. If there's a DNA, for example, just making an example with the DNA.
But then that is now his when he's writing his judgment, not to raise it so that it's debated in front. That is where the irregularity is coming from.
The main issue about this Makeleni is this thing which Rams was addressing Judge today with. Did you hear Rams tell? Rams said, if
But then basically, looking at the application before the court, the issues faced with the court at the moment of actually executing a judgment 174. This issue
Is
of
it fine now,
Makeleni,
guys? Check.
what is its relation to the matter before the court? The scene was also reconstructed, so that cannot be the case.
but he said something else again. He said, I admitted a so-called confession. So-called.
Yeah. I want to understand.
Is that saying he admitted confession or something which is called confession, and he has not yet decided whether it's confession or not?
Yeah, I want to understand the state's position on this issue, or the court rather, in for actually giving Baloyi so much time and the leisure to actually bring this before it, actually, as to what bearing does it have on the judgment that is due at the moment. What bearing does it have? Because Makaleni, guys, if you listen to the statement, maybe let me break it down. If I am defense, actually, if ever the state wanted to bring that statement, for me, that statement, I think it gives a clear picture to us that there were no intruders, and I think they should have explored it even much further. They shouldn't be afraid, but we know the tactics of the state. So they bring all the statements here, and then they want, the defense or the defendants basically to actually trample over that, so that certain parts of those statements can actually be admitted to the favor of the state. So they want to rely on the defense negligence, or on the defense incompetence, or whatever that it may be, that they think that would be the case for them to actually go on and have this assertions admitted into record. So, of which the defense did pull out some of the statements that they are not even intending to use, or they act as if like they are not intending to use, whereas they know that their plan is to actually have this admitted through the defense. So the statement of Makaleni, this is what it says, guys. The statement of Makaleni tells us that he says, before I heard the gunshots, there were 2 men outside. He does not say 3 men, he does not say 4 men, he does not speak of a vehicle by the danger box. And he says that this gentleman, they smoked and they went in, and just after they went in, then that's when I heard the gunshots. How is this valuable to this assertion of intruders? It is because he explicitly say that after these 2 gentlemen went inside, then I heard a gunshot. He does not say another gentleman, 3rd guy, was outside, or there was a vehicle that actually dropped people or out, according to the confession of Ntanzi, basically. So it does not corroborate the entire confession of Ntanzi and the entire assertions of the witnesses from the house. So now, how is he corroborated there? he is actually corroborated by Tumelo Mazala and Mbogosi Sitwala, who say that we were outside, Tumelo was smoking, then we went inside. And if you go and listen to the evidence of Tumelo Mazala, he actually said, just when we enter the house, Kwaba Nomsindo, then Obaloi stopped him. Then the defense has to take it up to there, according to the statement of Makaleni, to corroborate to Melo Mazala, who actually gave this evidence to say, Tumelo Mazala says, just when we forget about what Baloi says, what Tumelo did not say, it is there on record. You take it up to there a lot further. You say, Tumelo tells us that after speaking, exactly wanted to go after that issue. But he was disrupted by the court, he was disrupted by the state, as usual. And he lost touch with his point. And that is what he should have went for in his argument as well. Now, he should have went straight up to that point and actually never take that point further and say, I am limiting this version of Intruders to this point. And up to this point, that's when the noise started. And we know that according to Tumelo Mazala and Mprogosi Sitwala, when they were outside, nobody passed them to go inside. They have never made that in their statements. And they did not leave anyone outside who was waiting for these two guys when they went in. So that issue of intruders is broken down into pieces. It does not exist. So that statement of Makaleni is valuable thereof. They can go ahead.
No, I think it's just that I didn't know the statement, but I was just outlining.
He says himself in his own words, "Kwaqalumsindo." He says himself in his own words, "Kwaqalumsindo khona lapho," something like that. So this Msindo is not before he sat down and some people came in. No,
It's not caused by the intruder. Not saying
this Msindo, it's like they walked into it.
I see.
No. I can see people want to speak. Maybe. Oil, can
Yeah,
come in or proceed?
Yeah, you can come in.
Nox, if Noxy can start, guys, he's been parking here for a while. Noxy can go.
Unoxy can take it. She's fit, most. She can take it.
Hi guys. Hi Marshall.
Hi.
I think you assist here with your knowledge. You know, my issue with the statement is that Magaleni speaks of, I saw strange people go garage. How many people go to a garage? So now, if you see some garage, does that mean these people are going to commit crime? He was not specific. For me, I feel like statements high, especially with the garage, but it's very vague. It's not specific. It's not even assisting with regards to a crime scene because he could have seen anybody at the garage, and he's not even specifically saying, I saw a short guy like this. He didn't even give us the facial appearance or the construct of those people, number one. Number two, like, is it Umako? Yeah. Spoke about, the fact that he said he saw people standing outside. Or because he didn't say, I saw the people that were inside Makumalo's house, they were smoking and two people walked in. There is nowhere where in his statement he's stating that people walked in. which for me is still, it's still not still talking to Umube or Untanzo or anybody else for that matter, because we know what Tumelo said, they were outside smoking and then they went in because they wanted to Vanelisa Kumalo to leave, right? And there was Togo and who's this other guy? Tumelo, when they were outside. It could have been anyone. The identity kit was not specific to say he saw Mube or Ntanzi or anybody. For me, I feel like statement to Saha is not specific. I don't know how, it's not assisting the state, nor is it assisting the defense in the way I understand that statement or that whatever that was read, Makele, because he was not specific to say these people, it was this and this and that. I saw them, they had these features. He says he was holding something in the hand. I don't think he was specific to say it was a gun. He spoke of a gold tooth. The 5 accused in the court, who has a gold tooth in the upper insert? So far we know Ntanzi doesn't have, Nube doesn't have. Who else has? I don't remember anyone having the same, the gold tooth, other than Ntanzi and the 2 people that they said they went in, which is Ntanzi and Nube, allegedly. So for me, the statement, either way, does not really assist the state, or nor does it really assist the defense, because he's not specific unless the law says it's fine, we can take it in like that. Because it's not, it's very vague. It's not saying who was there, where was the car. He speaks of a green car. Intervention says he was sitting in a green Honda car just opposite the street car of Makumar.
Yeah, Noxie, I beg to differ there when you say, on the fact that you say that it does not help. Well, it helps massively with corroborations of facts, because we have a series of events here unfolded by the eyewitnesses, and up to a certain point that I spoke about, the statement of Makaleni is corroborated not only by Tumelo, it is corroborated by Mtogozi Zitwala, it is corroborated by Ntabiseng. On the admissions of Ntabiseng to say that the vehicle that was outside, it was a Honda Balade, a green one. So Makaleni was actually outside, and actually proving that he was outside, then these assertions made by the people in the house of intruders, but at the same time corroborating somebody who is now factually proven to have been outside and seen these certain individuals. And now they corroborate.
Just to interject, but both of these people, they're not saying anyone went into the house. I understand when you say it's corroborating some facts to the story, the eyewitness. But both of them, Ntabi saying no Makeleni. They're not saying I saw 2 people walking in. One is saying I saw people running out. One is saying I saw people standing in. So
no, I think you are missing me here. I think you missed me. I am saying parts of the statements when you look at the series of events. So firstly, Ntabiseng corroborates Makaleni to say that there was a green car outside. Then remember Makaleni from his position when he sees that he does not know that this vehicle now was going to 135, or it was going to 136 or 137, whatever. It is parked outside. You understand? So that alone, an idea of belief that this person was actually outside, because he saw this and it was corroborated. That's fact number 1. Fact number 2, it is that he says, before I had a gunshot, then there were 2 gentlemen outside who were smoking, who actually went inside. Then just when you park it there, Tumelo Madlala says, we were smoking, and then just when we enter the house, Kwatkalumsindo. So that means Umakaleni is correct in saying that he saw 2 gentlemen outside, and then these 2 gentlemen, just when they enter, that is when they corroborate him to say as well that then the noise started. So it is up to the court to draw an inference from there, from what the state actually alleged to have been intruders, to say that there is actually no intruder. An inference can from that. So that is what I'm saying, that if the defense went all the way out to actually park this issue right there where Tumelo was stopped, you cannot erase that from the record. They must park it from there. And then parking it from there, then the court will be able to draw this inference that there were no intruders.
But then they didn't go that far. That's the thing now.
That is what I'm saying, that they didn't and they should have.
Yeah, that's what I'm saying. In this case, with the quoted versions or whatever that was read by Uram Sepil, how is that helping the state? Is it helping the state? Is it helping the defense with what is quoted?
Look. The argument of what I'm saying now is that the argument of Ngumalo argued the issue of, remember, he argued charge by charge, right, against accused number 4. So what I'm saying is, because he wanted to pursue that point through the cross-examination of Tumelo Mazala, and he was stopped or interrupted or prevented from actually pursuing that, then in his argument, he should have taken it up to that point to actually relate Ntabiseng, Tumelo Mazala, Mtogwesi Zitwala, and Makaleni himself. Up to that point, then the court will actually say, if there were no intruders, then it's impossible that they were actually accused number 4. If you understand my point.
Noxie.
If you guys remember what Ratat said to Urams when the trial started, are you guys saying we were not there, or are you guys saying there were no intruders? You must choose one. So if now they're going out of their way to try and prove there were no intruders, so they're trying to say they were there. Peter, you can assist with them, because Rata, remember how hard he was on Ram, saying, are you guys saying you're not there? If you're saying you're not there, that's what you must go with. Other than the fact that you're saying there were no intruders.
Okay. They could say both, and then the state is...
I understand your... Yeah.
To prove.
I understand your point, Noxie. Their position, yes, is that they were not there. But then now, he's arguing with us. And at this point, accused number 4 is apt to be one of the intruders. So now, in his argument, taking the point up to that point, then it actually enhances the chances of him being exonerated.
You know what, Absolute, foot, just to add something. You know what the Absolute is explaining here? It does make sense, and again, it can be useful to a defense on their state case. Remember, for them, they need this warrant officer who took a statement from Makaleni to confirm what Makaleni said, because indeed what you are saying, because even Tumelo is the one who tell us that they were smoking outside and they went inside. That one is on record. As much as he's been stopped when he started to mention an issue of a sound. But what is on record is what he said: we went outside, we smoked, and we went inside. And Makaleni in his statement, he confirms that he saw 2 people standing outside after they went inside. That's where he had the gunshot. So if they can able to get hold of Mr. Warrant Officer, I forgot his name, who twisted from a No, Stencam. There's another one who took a statement now from Makaleni, not who interviewed him. It's can someone Yes, if they can get hold of Mutwedi, because Mutwedi is on that list of witnesses. And we know now it is Mutwedi who said he was there. He did Magena. His statement was read in court that Magena took what you call he is the one who forgot. But he spoke about Magena committing something, taking a projectile, putting a projectile somewhere. He is the one who said that in his statement, and hence, Malloy never called him to come and testify in that court. So, if a defense can able to get hold of Mutwedi and said, Mutwedi, you took a statement to Makaleni, and this is what you said about Makaleni. This is what Makaleni said. In other words, he can confirm the hearsay evidence of Makaleni by confirming that indeed he took an oath under his presence. This is like that, Fisher.
Yeah, it's like that. If witness is normal, you call the taker of the statement and confirms everything.
Hence, then the issue of the statement can come back to haunt Malloy if the judge decides to use the statement or to stand in that court. If then the defense can quote Mutwedi, this can come back to haunt him. But we've got this evidence. Two people entered the house who were smoking outside, and Tomeo is mentioning the same thing.
I just want to ask a question here to all of us. It's either maybe I am lost or whatnot. My understanding of Makaleni raises his ugly head, may his soul rest in peace, when Ramusipili was reading blow by blow of the people that the sketch artist had a conversation with regards to the sketch artist trying to formulate or try to form that makeup of the sketch of the alleged intruders. Now, that is where in that statement, who's this? Echo. Yeah, that is where in that statement, after Zandi, Kelly, and them, Makaleni is mentioned last to say Makaleni came and gave detail of what he saw. A guy of 25 years old, the gold tooth, dreadlocks, you name it. But now, my question is, in that court of Rata 636 that started de novo, did anyone took Makaleni's statement, not what Makaleni said to somebody else's statement, but what Makaleni said in his own statement, and it was placed on record? Or because the one that I know was placed on record was the Steenkamp sketch artist, where Ramsipile put it all on record, but he focused on those who were in the house as to what they told Steenkamp. But now, was the statement of Makaleni that he wrote either in 2014 or later before he passed on, was either of those statements, either in 2014 or later, was one of those statements, was it placed on record, yes or no?
Okay, baby oil. Insofar as I listened correctly, we address the advocate Ubaloy said they did not place in record the statement Skamakali.
Yes.
What was placed in record by the defense was Stenskamp assertion in his narration in his statement.
100%.
Number one, that is why I was saying illegal principle, statements of witness often must be handed in to be considered as evidence. And the taker of the statement must take a stand. He must produce a death certificate of witness. He is on the stand, he is saying, I am the one who took the statement down. What is contained in the statement is what I was told by this witness. The reason for him not to come to testify is because he's dead. Here is a death certificate. That is a legal principle. No, in order to say, out of this statement, through witness, on the statement, witness that's not the case.
Yes, because I think here we just need to be careful because we follow this case. Because I don't recall Makaleni's statement either, let's just say with no procedure. Somebody says, you know what, I'm going to read Makaleni's statement in full. I've never heard that. Only portion is when Steenkamp, who's a sketch artist, when Ramusipile stood up during Gininda's cross-examination, then he stood up and then he placed it on record. And if focus Ramusipile was then, those occupants were in the house to say, Ukeli, this is what he saw. Umakaleni, this is what, and then Washala Ramusipile on the Makaleni part. But this is it that Makaleni saw ABC, but not that Makaleni's statement or affidavit was ever placed on record. The only person, because I don't want us to be unless I am mixing issues. The only person who's throwing jabs or always hinting on Makaleni's statement is Gininda. Is Gininda whenever he's cornered by a question, he'll say JJ and H8, and also the statement of Makaleni. Makaleni says, whenever he's cornered, it's JJ and H8, and the statement of Makaleni says, it's Gininda. Not that Makaleni's statement itself, whether dead or alive, was ever placed on record. The only portion it was placed on record, is via Ramusipile using Steenkamp as sketch artist to resurrect Makaleni as the person who contributed to some parts of evidence. And also Gininda, when he's cornered by a question or he's answering, when almost who Gininda gave a thesis instead of an answer. During his thesis answer, he would then hint or highlight that Makaleni said he saw them at the garage. Makaleni said this is what he saw. Makaleni said, you see Gininda, he plays with the mind of the court. That's how Makaleni is alive in this court.
Stimo,
Yes.
I think I don't know if I'm wrong. I think this came when they were asking Gininda Uguti, besides the confession, there's nothing that links these accused to the scene. That's when Gininda said, Makaleni is the one who also saw them. It's not only the confessions. If I'm not mistaken, I think there was something of that nature when they were asking him that what else do you have besides the confession? Then he raised the issue of Makaleni.
No, that is possible.
Yeah, you're right, and that's when they were taking him through the description by Makaleni, but on Steenkamp's statement. Is what you're saying on it, madam?
Yes. Yeah, that's what happened.
Yeah, so we don't have Makaleni's statement on its own, standing by itself. Whether that was procedural
Guys, can you
now that
please
it's
like the
dead.
live? Are you still able to hear
Why the judge wouldn't push,
very well?
push
I'm
the
not here
statement
all
of
the time.
Makaleni?
I'm
trying to
busy
figure out,
working,
as
so
much as I've got this
I'm
saying
putting
they
this
wanted
on for you so that
the
you guys
state
can listen.
to put some meat on it, but
Are
what
you
meat
still
on it
able
if
to
the
hear
statement was not
correctly?
read?
Very
I
well.
find it difficult.
Is the volume fine? Network fine now?
Yeah, the judge was quite aware of the
Please
hearsay
write
evidence.
something,
That's why
then
he
let me know.
insisted if it was the
Volume
witness who
fine,
was
network fine.
testifying in court who obtained the statement, because he was going to say, but the witness was here, and Nina, as a defense, you did not cross-examine the witness. Why you did not? So he wanted to go those lines insofar as I viewed the idea, but he was surprised because it was taken by Ugenin.
Oh yes, because he asked him several times. It was not Gininda.
Yes. He wanted to take that way to say, but you did not cross-examine.
Yeah. Now it makes sense.
But I think there are a few things which I think are adding up on this case. Number one, a sequence of events. If you look at the evidence of this lady that was outside, which is Mtabi saying.
Yeah, Mtabi saying, yeah.
Saying, I saw 3 people running and then I heard a shot being fired. If one looking at the sequence of events, it doesn't tie up with the evidence that there was something of that nature with Section 174 application in case of State versus Diwali. They only relied on a sequence of events in granting Section 174 in that case. And the other issue, which I don't think it was taken up further in this issue, which I think it can also play a role, the issue of identity. The identity by these people that were in the house is just, it's nothing. It won't carry any water in any court listening to what has been done in this case by the judge. If it goes to Supreme Court of Appeal, that particular kind of identity, they will throw it on the window. It won't work. There was no time to observe these people so that you can even be able to point them in the near future. You don't know these people, they come in there, then there's commotion, there's fight and stuff like that. Others are running to other bedrooms, and then, so how do you have an opportunity to observe those people?
The worst part is at night. How are you able to see somebody's
So even Magellan cannot assist with regard to identifying if those people were the accused or were not, insofar as if I look at the evidence.
Yeah.
That's what I would say in terms of identity. Makeleni cannot assist the court with that regard because it's at night. Even the people that were in the house were struggling to give us the face of these people if there were people in that house. So how is it Makeleni is outside when they say it was dark, but he was able to see somebody had a gold tooth in the upper jaw, and I don't know.
And I heard they were saying also the credibility doesn't play a role, but there are, like because in the Duan's case, they refer to the credibility of witnesses, not in a limited effect as they were arguing in this case, but it was referred to it, and one of the bases of the discharge was the credibility of witnesses. So the credibility insofar as relating is questionable.
And guys, let me just add.
I think the sequence of event will play a major role to Mnisi when it comes, because a shooter is Mnisi according to them. If he had to apply, if he was allowed to, or if he was given a chance to apply 174, because he would take court on the sequence of events, which does really create a problem to say, if this lady was outside, and because she's not saying that she had a gunshot while they were still inside. She said she only saw 3 people running out, and then she had against shots from there. So which then it means if those 3 people it's like that they are accused. They were already leaving the scene of crime, and somebody's been shot inside. It's a witness who was outside in the car. She said she saw 3 people running. After that, she had a gunshot. So I think that will really stand when they see would get a chance to put this 174.
I just want to add to the dilemma here. Right. I'm going to first go to Makaleni and I'm going to come back. Makaleni through his statement, Steenkamp, not Makaleni's statement on its own. This is Steenkamp's statement. Makaleni says he did not see suspect A. He only saw suspect B. Here is the description of suspect B. What he tells the sketch artist. The person was black. He's a black person, sorry. And he is about 25 years of age. That's why Kininda was saying.
Are we still audible, guys? Can you still hear us?
Yes.
Yeah. And then, oh, can you guys hear me?
It seems quiet, but
okay,
yeah,
no, it's fine.
What also?
What?
Oh, okay. Which worries me, it's how Louis plays the judge, because he plays the judge when he said it was the defense who brought in the statement of Makeleni, knowing very well that the defense never brought in that statement. But I also like what Admissibility did when he quoted that case at the end of it, because that case killed that judge to death, because he couldn't come up after that, because he said, I heard you, while we were still talking, because he finished, he said, you can't use this one, because this matter took it, by the way, and then he ended up saying, No, I agree with you. Of which those two cases which you cited, we never heard of, you know.
What?
Man. Wait. So, this is what this Makalini character says. He says, suspect B was black, 25 years of age, and he was about 1.8 meters, slender in build, slender build, and then a black hoodie, gold tooth with dreadlocks. He had a gun. Now, let's go to Kelly. Kelly says, suspect A, he was in his 20s. And then he was dark, and he had no scars. He had a gold tooth, and then he had a nakuzane with a revolver, and he was wearing that brownish jacket. And she was unable to describe suspect B. Uzandi agrees with Kelly. They were not able to identify suspect B. Who's suspect B? It is Undat.
Accused number 4.
Undat. A is a gun shoot, is a gun totter. Then A is accused 3. B is accused 2. Right. So Kelly, when he describes accused A, which is accused 3 in court. Sorry, when it describes the intruder A, which is accused 3, she says he was in his 20s, skin dark brown, no scars, gold tooth, brown jacket. He was carrying a revolver. And Ukeli, Zandi, Tumelo, and those 3, they agreed. I mean, Ukeli, Zandi, and Tumelo, they agreed. They could not identify accused 2 in that court, which is suspect B. Tumelo Mtokozi Zitwala, he was unable to identify either A or B. And obviously I've read with Makalin. But here's my point. I remember a constitutional court, even if we have to fund it as a public, we will fund it. If that's what it takes. We are more for the fact to accuse number 3 was brown. In complexion,
Yes.
And he was brown in complexion. He had no scars, and many gold tooth, and he was wearing a brown khaki jacket, whatever that thing is. Here is the thing, and here is my argument. I'm standing with this argument whether these guys are sentenced or not. When the opportunity presented itself, they went and whether he was a neighbor, whether he was a next door neighbor or 3 meters away neighbor or a neighbor around the neighborhood, it doesn't matter. For the mere fact that, according to the narration of the story, when the scuffle happened, shots were fired, the person who remained behind at all material times, it was Makumalo Senior,
Hello,
the mother of
Kelly.
the house.
Njani.
She was the very
Or see,
person
the problem is they try
who
to
went
that code
there
every
and
time.
identified Uzamuguhle. Let's describe Uzamuguhle.
Guys, I'm busy with
Uzamuguhle is dark
washing.
in complexion.
I'll come and read all your comments.
Uzamuguhle had
Please listen to the radio.
Uza-
It's TikTok. The
Uzamuguhle
account on TikTok
fits
is
the
Mashana.
description of the intruder, and that identity
I'm out. I'll be back.
or identity parade was done less than a week after the incident. So it was still fresh in Makumalo Senior's mind and memory. Now, how did the gun totter change from being dark brown to a light-skinned person like Mube sitting in the court? Because Mube, you can see from birth, he's always been like that. How did the gun totter change from being dark brown to now light-skinned?
That's my argument, baby, all to say, features which are putting forward as the identifying features will not stand in any court to say the description they gave fits the accused that are before the court. There are no distinguishing features which make him to be different from any other person. You can't say we differentiate them with dreadlocks and stuff like that. No. How many people with dreadlocks?
Exactly. I always argue that point. And another thing, when I finish, I always argue. Now that we have a science, I don't want to, let me call it a medical report, which is still part of somewhere in the layers of science, although it's a medical one. A medical report that comes back. Umakaleni says suspect B, which is Ntanzi. And I repeat, suspect B is Ntanzi. Makaleni says that suspect had a gold tooth. Ntanzi, when they were still busy with the investigations, the police did not find a gold tooth when he was examined, and the doctor was in court. He testified that this person, okay, they went through all checks and balances and whatnot in terms of his tick box, a preliminary check to say, are you injured, are you, let's skip all that. But when the main reason for him to appear there, it was to be checked whether he had a gold tooth or not. And the answer was, the doctor on record, he came in the court, he said, this accused too, I tested him, checked him, he did not have a gold tooth, he never had a gold tooth in his life. Just there. Just there. I'm not talking about the doctor, the one who where he treated Longwe because of the bullet was stuck in his ankle. We're coming to that someday. But this one, he came to the court, took an oath and everything, and he says, yes, this is a guy that I've tested, and I've checked, there's no gold tooth. Now, on that strength,
Usiyaphi manje?
Ikhona in identification lab.
angithi naye uMakaleni ayisho. Uthi uMakaleni.
No, I'm saying which can help the court to convict. Is there any evidence?
No. You can't convict now.
No.
And just to add on that, with these 5 accused, those that were in the house were never called to ID those people. There was never an ID parade to confirm if they can see this one was in the house or they see a familiar face whatsoever like they did with Umbat. And their reason was because of what happened with Umbat. So right now, how do we trust that the people that are before the court are the correct people?
That's other thing, my sister, that need to be considered more as well. The arrest of Umbat. It's very important. It's very important in the witnesses, in the identifying witness making a mistake with the identity of the suspect. It's very important.
Now, Fisher, can Bata, let's say, whether the defense win or loses 174 application, to me, really, I'm not too worried whether they win or lose. But can Zamuguhle be called as part of the defense witness? And
Yeah, you can be called to come and say, I was arrested because the description it was given fits me very well. And also, it is common cause as well, even if it doesn't come, but it's common cause.
that he must be called.
That he was arrested because
He was arrested, yeah.
Yes, because of the description. They just need to address it, to address the judge about that.
Because I'm just thinking, I don't know whether it's procedural, where you'll get an arresting officer and the IO of the time who took a statement in relation to him being arrested. And
yes, they can do so. You can do whatever in your defense. You can do whatever you want to do to put it out in the state case.
Yeah, because I think they need an arresting of an IO, an arresting officer who arrested and took a fingerprint Kazamuguhle, and also the statements that were taken insofar as that events. Why was he arrested? Did Makumalo make any statement to that effect? To say, yes, it is him, I saw him, he was dressed like this, he was walking like this, he was limping, and now that I see him, it's him, because we need that statement that pinned Zamuguhle to that arrest, because he was arrested, and only when he appeared in that, in that magistrate court, the magistrate says, there's no case here, Kuman. So, but now, here is another catch. And we've said it before, and I'm recycling the same thing. I'm still saying with the others, we share the same sentiment. Zamuguhle was not arrested because he was arrested because they need to arrest him. Uzamomuhle was arrested to enhance the narrative of the intruders.
Exactly.
Not because he was arrested, because they just said, is there anybody election ofana now this guy named Discrapela when they were cooking this case? They said yes, there is Fisher who lives that side. Let's go and get Fisher. They went there and go to Zamoguhle. They knew go to Zamoguhle will be acquitted. They knew. But
So they had started already to play their games anytime they arrest Usamoguhle.
thank you. Now Kininda comes and spins it and say, oh well, yeah. Sure.
Oil and Fisher, while we're still indulging to this, I feel like those people who didn't put 174, the strong case, listening to what Oil just explained about the description itself, it's killed this case, and the issue of Ulokuza Umbata. What else should these people answer if you've got such evidence before you, especially for identification? And it's the issue of there was somebody who went, the people who were in the house, Makumalu were told, she identified, she pointed out Ulokuza Umbata. So with those kind of evidence, really, the judge will find himself very difficult to defend, because as much as you can mention this thing of what you confess, but you deny confession. Now, after you deny confession, your lawyer who was a creative stage of he will come and say, but why accused person? Why should it go for a stand if this is the evidence which is before you as a judge to say the description, the person was arrested, and everything and anything. It's they've got a strong case really. But let's see what will happen. But I can't wait, because it's looked like she was very she's waiting to bring her first witness next week.
No, issue of 174 or even acquittal, I don't think it's closer to any of the accused by mere looking at this judge. You know what normally happens in court? The judge will engage the practitioners, both practitioners like for defense and for the state, but not the way it is happening in court. In court, Balo is being assisted, if I may put it like that, and the defense is being criticized all the time. Am I still audible?
You are. We can hear you. We can hear you.
That is my main concern. That is why I'm saying judge was not actually engaged with practitioners, but was assisting and criticizing on the other hand.
Even the last statement when he said, I keep quiet if he make a mistake with the law. He said if the state make a mistake in law, I keep quiet. But he's not saying the same thing when the defense make a mistake. According to him, he doesn't engage them now and then. And he will put, like he quoted the section today, of which when the was read through, he said no, I don't mean that. So you could see that he was trying by all means to say, by the way, bring something to me. And it couldn't, unfortunately it couldn't. And I'm happy that Numalo never took it further to engage the judge, because he would have wasted his time.
And it's always like quoting case of 1949, which has been changed more than 10 times. With the danger with those cases from 1990, for example, going backward, the constitution was not there. So most of them have been changed with the introduction of the constitution. So you can't really rely on cases of 1949 when it's come to something like confession, identity, and pointing out admission and stuff like that. You can't rely on those cases because there was no constitution by then. Sure, was it?
Man, I had a question earlier. I want to understand. Don't ask a question, but I think I've answered, but I'm not sure. Also, I need a confirmation from you. If the counsellor is quoting a portion of statement from statement which is not handed in, not quote a portion, does that mean that that portion is going to be admitted as evidence? I don't know if I'm making sense.
Yeah, as I've said earlier on, if you introduce a hearsay, you are admitting it. Yeah, that particular evidence is in record. Even on cross-examination, you need to be cautioned not to cross-examine about the hearsay. But what I'm told here is that by Baloy is that this evidence statement of the witness who died was not handed in. Therefore, nothing was quoted from his statement because it was never used. So what was used was a statement of another witness.
No, it makes sense. Thank you, Mother. It makes a lot of sense. No, the last one before I go back to my work. I don't know if I did pose this question. Maybe you're not here. I don't know if Rata was fearful or maybe trying to clear the tracks so that tomorrow won't be held accountable or not. If the judge introduces evidence in court and then a particular party runs with that evidence, does that mean that evidence should stand in court or what? When the judgment is being handed out?
Yes, apparently what happened here, Urata talked of something which was not evident, statement of Magdalene. It was not an evidence. Normally, a judge can engage both counsels to say, in your application, there is a piece of evidence which is in record. Can you address me on it? But in this case, he was talking about statement which is not in record because he believed the statement was taken down by Ukeninda. That is why he was insisting that it be used because he was going to say, but Kininda was here, you did not ask him about the statement. He wanted to do so, but unfortunately it was not taken by Kininda.
So meaning exactly. No, it's better. I think
that is why he asked him several times if it was taken by Kininda, and he was surprised.
You are a conspiracy theorist.
I better be a conspiracy theorist, but at least my conspiracy has been proven correct. Has been correctly proven. Because really, we cannot just shush when we see something is not correct. Really, the way he tried to persuade Baloyi and ask him, or maybe the other counsellors, then Peter, Rata's conscience is still intact. He understands the evidence. He knows the implications. So I would give him a bit of slack to say that he can give us the judgment that we expect. If he's cautious of the implications and the procedure, we can safely say that no. He might give us what we are expecting.
What are we expecting, Abraham?
What I'm expecting and been advocating for all these years.
Acquittal.
That I'm hoping for acquittal. I'm hoping for not guilty verdict. So if I say we, I think I'm putting you guys in a cat that you did not pay for. So let me just say.
I was just making sure. Can I ask something?
Can I support Abraham before you ask something?
Okay.
You guys, if you notice, there are two instances where judge withdraw some statement. You know what he said yesterday when he allowed this guy to read through what Mobe said, accused number 4 said before court. I think this morning or yesterday, he said, but that one cannot be used before because it is not done accordingly. He has not yet pleaded guilty or not guilty. So it's not, you can't use
Yeah, it's a disconstitution.
Yes, it shows that he is quite aware that I brought this thing in and this guy is now taking it up. Now, even on the second distance, which we withdraw, because even one when maybe let me compare, even when Balloon started to insist that you can use it, he said, "Yeah, sure, you can use it," but he said, but even if you use it, it doesn't stand, you know. So you could see where he is at this stage, and I can agree with you, Abraham, that we might find something strange with this judge. This judge does go and do these things when he's alone, and he comes to his sober senses when he's alone most of the time. I think when he's in court, he gets excited, but when he's alone, I think he does consider some facts and see, here, things are not okay.
Yeah, I can say granted, but hey, I doubt. Hello, guys. Yes.
Incredible. Credibility one. Incredible one.
Yeah,
Sorry, incredible. Before you speak, I have an ask, then you can speak. Sorry, sir.
all right.
Thank
Incredible. Please make sure you have your certificate in order, ne? Because I have questions
How?
and qualifications.
Uqalile. Anyway, guys, before we even go forward, ngicela ukubuza uNxumalo wayethe on the day when they were talking about the application for 174, he will not respond to Baloyi, ne? Ibrahim, come in.
Yes, he did say that.
So,
But yesterday, carry on. I'm just saying. I'm putting a
but
blame
yesterday
on
what?
the assassination. No, I'm putting a blame, okay?
I was under the impression that he does not want to
Carry
respond.
on.
I was under the impression that he does not want to respond. Then today, I saw him as someone who wants to respond but was not given an opportunity. Did I read that situation wrong? Because what happened there, Judge Rata was in a hurry to go after that commotion that was happening about struggling evidence and struggling whatever, and then Ramusipile trying to educate people that can't educate him and all of that. So then the next thing, there was something that was happening that was not right. The next thing, they were out because SAPC was not giving us. So I wanted to understand, did he really stood with what he said back then when he said he won't respond, or he wanted to respond, but because of what was happening, he couldn't because the judge hurried the entire situation and left?
He was not prevented.
Yeah, he was not prepared to respond because he saw that it would jet this thing. Because if you notice, by the way, but when God will respond, then they will go for what you call the break. Then they will come back. So that delay, he wanted to keep that delay, but so I keep standing up and sitting down. But no, it was clear. He didn't want to respond, and secondly, he wanted to address the court about what had happened. Not because it was responding. He just said to court, put it on record, say, what is happening now is not what's supposed to be.
But Ubalo cannot come back after he replied.
Okay. Then I'll go down. Fihla Masela ngicela usenze this understand okanye, okay, make me understand on this. Now that all of that happened, and then Judge Rata goes away to do the judgment and stuff like that. I don't care what his judgment will be, but there's a lot of things that happened there that were not right, and it seemed like somehow he became aware because they were also put on record.
Yes.
They were also put on record, and then he was very self-aware because that's why he was running away, in my view. If someone is listening to that, and someone who is at Rata's leak, let me put it that way, and is listening to what was happening today, people are trying to address you as a judge, ukuthi what is happening here, it's not on. The procedure and everything that is, he is not really addressing it. Instead, his responses are to attack their knowledge of the law and stuff like that, because that's what he did. He ridiculed the defense lawyers, even though they were putting out their frustrations. And there was something that Umnisi said. What Umnisi, I know how he operates the state. I know how the state operates. He did not go and try to understand as someone who's interested into solving issues that will be detrimental to his courtroom. He was not interested in that, but instead he added a petrol in that fire. What happens in situations like that? Please educate us.
Yeah, as I said earlier on this, that there are remedies for anything that is happening in court. This is the court of first instance, and there are other courts above this court. You can take the matter to review if you feel there were irregularities. It's optional. You can take it to appeal. If regularities led to the conviction, you can take a matter to appeal, whereby the result will be to acquit your client if they are in your favor. But there are remedies that you can take the matter to other forum, which is above this particular court.
While the court is still in process right now.
If you want to take it now, when the matter is still in process, you can make an application for a review, special review.
Okay.
But I doubt that procedure will delay the matter, and hence they are on legal aid. I don't think they can resolve to that.
Okay. Legal aid uyayibhatalela appeal.
Bhatala yonke into.
Oh, nice. Okay. I-special, agent appeals uyazibhatalela.
But yonke into, even this 174 is paying for it because it's a procedure for trial.
Oh, okay. All right.
Yeah.
Thank you.
Yeah, Fisher, I want to ask about because it seems this state case is more on proving a common purpose and then using executive statements. So my starting point would be, what is I've noticed what the state wanted to use Uzungu and 205, that number 3, and then the statement, of course, is Kantanzi, the confession, because that is where they want to take executive statements. And then they also use the evasion number 4, which they say he was saying with at all times he was with number 2. So then there's this issue. People who support the state's case, they want to separate the phone from the person. So at what point then, because if you can't separate the phone from the person, then you can't prove Ugutu number 4 the crime scene. And you also cannot prove, of course, I don't agree with the way they want to use Uzungu to prove the common purpose, because they are saying what Uzungu said they were together at the hostel, and then they are using 205 to say what it puts him in the vicinity or around the hostel because of that tower. Although, of course, you cannot pinpoint, because I'm looking at E205 scientifically to say what as long as there are no coordinates, we can all be pinning on the same tower, but on different sides of the tower, for instance, because there are no coordinates to actually place our exact positions around the tower.
Let me start by saying, firstly, my confusion with this case is whereby state, or the way I look at the evidence by Lidangakon, they are saying, okay, he was communicating with one of the accused, and they are alleging what he paid. It means he hired the hitman ukuthi babulale umuntu.
Yeah.
That will be a conspiracy to commit a murder. But this person who hired the accused is not the accused before the court.
Yet they've determined which is she hired.
Yes, they determined, or they are saying that in court.
Yeah,
That's where my main confusion actually is. That's where my main and with regard to Uzungu is not like a 204 witness who was the part and parcel of the planning. The mere fact that Ubabone Bendaoni, to me, doesn't give a conclusion to the court to say they were conspiring to kill. Yes, he said at some stage they were saying Senzo died before even it was announced. But I don't think that itself can suffice to convict or accuse with common purpose and conspiracy and stuff like that. Why who paid these people is not part and parcel of the accused as a main accused, because he is the main accused.
But in terms of indictment, she's actually a victim because the robbery is attributed to her, to her as the victim. It's actually
yes, in terms of that's the case. But in terms of the evidence in the matter,
yeah,
and in the conspiracy, because they are charged with conspiracy to commit murder, they are charged with murder. Why he's not the accused?
So, in common purpose, at what point does the state prove it?
So, you remember who they are saying they were together planning. If the common purpose works like this, if I'm present in the planning and if we execution I'm not present, but I'm aware of what is happening and I associate myself with those, even if I'm not physically present there, I will be also convicted because, number one, I did not distance myself in such a way that I even called the police to say there are people who are going to commit the offense, interrupt them. So I did not associate myself with the criminal offense. Then I'm going to be part and parcel of the accused.
Yeah. So my question is, according to evidence that we have, at what point does the state say they have proved the common purpose?
By leading evidence, and this evidence says they were celebrating, saying Senzo is dead, and they were drinking that particular whiskey and stuff like that. They say they were planning, and after planning, they were celebrating.
So the planning should come before.
Yes, they planned when Uzungu was seeing them in the hostel together.
No, but Uzungu never saw them like.
I never saw them before.
At one go to all the five together. There's no way where he says.
They're bringing in Ukeli, communicating with one of the accused.
That's part of the plan. But then, do they have that evidence except the confession? Because they don't have that evidence in terms of the 205 number 3 does not show any communication with Ukeli.
Are you sure?
Yes, it doesn't. In 205, corner number. In 205 Kelly, Yama data calls which they are struggling to actually convince, unless if Urata is convinced, go to number 5 actually communicate, because that is where they want to
yes. That is their argument. That is the state argument to say, okay, and accused number 5 were communicating.
Yeah, so
I'm not saying that the evidence is correct, but that is their argument.
Yeah, I'm following that because they've been struggling to actually convince. I remember Austin came twice. At first he said it was a normal call, EMTC. Then when he was caught out, then they brought him
PPM.
Hoping he had come back with proper 205s, which showed which they actually substituted number 5 in place of Ada and Lucenzo. Then they had to bring him back to say no, actually it was a data call, it's in the downloads. So then it all hinges on what Urata is going to agree, whether it's going to take. If it takes sustained evidence, then the common purpose would have been achieved there. But that is highly contentious, considering what Hussein was actually evidence sustained was so much in shambles.
No, case as it is in court. This is court of first instance. I don't think with anything relating to acquittal can result in this court. But I think in the next forum it can.
Yeah. Because and then there's this issue Makale. What was the is it ngazi legal or moral what brings issue Makaleni who is not in the heads of the state.
Yeah, as I've said like few times that judge can engage counsels with a certain point, which is part of evidence. To say, for example, address me on the evidence. But unfortunately, statements Kamakaleni was not an evidence. That's where there is a mistake. That is why he was asking if it was taken by Gininda, because he wanted to say to the defense, but you did not cross-examine him.
Yeah. How is it not evidence? Because it's part of the exhibit last intel.
No, his statement. Is it a statement or some other things which he was informed by Makaleni?
That is where I don't understand.
The attachment.
If it was part of Austin Camp, then I would understand. But then there was this issue of which Ubaloi was talking. Ubaloi was being sneaking. Today, he was talking about Austin Camp. But that day when Urata asked about the statements from Academy, he actually gives the name of the officer who took that statement.
In fact, Ubaloi Daishoy Uti. Statements Kamakaleni as admitted in evidence because the defense introduced a statement which is speaking of statements Kamakaleni. So it can't be like that. It doesn't work like that. If you want Kamakaleni, you must put it in record. It's Kamakaleni itself, not the statement. Justin Camp is Kuluma. The statement is Kamakaleni. No, because it doesn't work like that.
Because the defense relied on statements Justin Camp, not statements Kamakaleni. Statements she talks about everybody who contributed to IDT, not only Umakale.
Yes, but Umakale is mentioned.
Yes. So you cannot single out Umakale and say then because Umakale has got a statement elsewhere, that statement should also be included.
Yeah, no.
We wanted to do.
Once you statements are, they must call statements into the record and call the person who obtained the statement.
Yeah, because I believe with the statements from Kellen, then he has got more meat that Ubalo wants to chew.
Yeah.
But I'm still struggling.
But if I listen to the content of the statements from Kellen now from other colleagues here,
statements from Kellen are actually. Unless if people are reading from the newspaper, it says is what he gave to Ostenka. Which is only that part, that portion, which focuses mainly on the description. And then among newspapers, they went on to do their own digging and bring in a statement. Because this issue of even they talk about Ngwenya, who was with him, was also shot at some point. But that is where sorry, I think we had a problem. But what were you saying? Hello?
I don't know what's happening.
No, I think we're not So I'm saying, can you elaborate more on my executive statements, which they seek to use?
The principle insofar as confession is concerned, is that the confession by one accused is not admissible against other accused. it means those accused that confessed will confession yabo must not affect accused number 4. Case law ubuhlongo and goals, it says it only affects other accused if his statement is construed to mean the executive statement. Then what is then executive statement? The executive statement, according to writers, is a statement whereby one accused is admitting to the commission of the offense, but if it goes on to speak about a conspiracy to commit a murder or furtherance of common purpose. So what they argue is they are saying a statement of Umos, for example, is going on to cover all those areas. That is why they want them to be admitted, not only as a confession, but as an executive statement, because they cover the requirement of executive statement.
Umos talks about different people.
Yeah, yeah.
So then all the parts, everything that Untazi said will then be an executive statement.
It's an executive statement because it relates to the conspiracy or to furtherance of common purpose.
Yeah.
And they are saying there is evidence outside that particular statement, which they call it evidence in Lude, which implicates the accused. That's a requirement for the admissibility of executive statement.
Yeah.
They are arguing that the evidence, which is the evidence in Lude, the identity, the evidence, Yazungu, my cell phone records, and all notes, all this evidence that it was led. That's what they are relying. That's their argument.
Yeah. Then if we look at pieces of their evidence that constitute evidence, like for instance, I did
forget about that, but talk about the witnesses that came to court. Were they clear enough to establish the identity of the accused?
They did. The two of them did the doc identification.
If you look at what was happening in the scene, were they in a position to be able to see these people? You are saying they were good, like they did. For example, they are mentioning the culture. Anyone with the culture, or anything which they mentioned, which is unique with those people and which is unique with the accused in court, which confirms that they are the one that they were in the house.
And the issue of the court truth is contentious in that Orata also came up with the suggestion that maybe it was an artificial. And then Ukininda went to that. Maybe Ukininda took that to be his own evidence after Orata said that.
Yeah, but those are the things which can be construed also as irregularities.
Yeah, because Orata is the one who came up with it.
But I was just asking about identity. Are you satisfied with they were able to identify them?
No, the fact that Uzandi, remember Uzandi went for 2 identities after Zamobuse. She was there. She also allowed Uzamobuse to be arrested before court. If she knew that she was then why would she not arrest the police with her?
Yeah, what I'm saying is the features that they gave are just general features which anybody can have them. It's not like they are unique or pen. Being short, there are so many. How many people are shorter than other accused in court?
Yeah, and the fact people are using dressing because Ukenenda is the one who comes up with a khaki shirt after seeing a picture at number 3. But Ukeli said a brown shirt, a brown jacket with a wooden collar. That description.
If umuntu ethwele isigqoko your identity yakhe is disturbed as well.
Yeah, and that it was proven with it excluded everyone in terms of DNA.
Correct.
That is why the state is struggling to
That is also another crucial evidence in DNA. DNA, remember, is an independent evidence.
Yeah.
Which if it's found, if your DNA is found on the victim of a rape, for example, you have to have an explanation why it is there. So is similar must apply when you are excluded on the issue on the exhibits that were found in the scene, which exclude whereby it is alleged which it was worn by you, but it excludes you. There must also be an explanation as to why people are still insisting that it's you when you were excluded by independent evidence.
And then there is another point about Uzungu. When Uzungu talks about the shooting of Upabi, people have been saying about people who are for the state case have been saying about when Uzungu talks about the shooting of Usinako by Upabi, and then people have been saying that is not part of the trial. But wasn't he trying to use that to bring in the issue revolve? So, and he allowed Uzungu not to answer that question. Uzungu Pela refused to answer that question because he realized that incident actually took place in 2017, not in 2014 and before. So that evidence becomes important in the sense that how could Uzungu talk about someone, about an event that has not yet happened? An event that happened.
With me, it's not like I don't think I can be able to deal with evidence in the case, but I would rather deal with the illegal principle. For example, to say this is done, this is not done, because the evidence it depends on the decider of the facts, on the of the presiding officer whether he accepts it or not. So it's very difficult to deal with the evidence to say precisely this is not correct, this is correct, but like Ramsa was reading that particular case law, that's a correct position as to how you admit hearsay evidence.
Yeah. So what was the point there when it was the end when he talks about the constitution, even Tubalo talk about the case there, when Nomado is saying he hasn't proved this and that, and then
Section 3 in my requirements are corner that you need to prove if the evidence has to be admitted in terms of Section 3. If we hearsay evidence, there are requirements there. Ubaloy did not mention those elements. And Uramsa was saying, who judge to speak of hearsay evidence, statements of hearsay evidence. When state case closes the case, the state must make an application that such evidence be admitted as hearsay and equal pronounce itself closure of the state case, not at a later stage to say I am admitting this evidence, because when you decide to put your witness or your accused on the stand, he must know what case is he defending. He must know what evidence is standing against him. So if you admit it after he testified, it prejudices the trial. It's unfair to the administration of justice, and it's unfair to the accused. It actually contravene our rights to accused in terms of Section 35, a right to fair trial.
Yeah, because you can't defend yourself after the fact.
Yes, you can.
But I'm still puzzled. Maybe it's because I don't know that constitutional court judgment. But it seems it didn't. Because
I did not hear him saying that. Maybe I would know which case he was referring to.
Towards the end, I can't remember the name of the case, but it's at the very end when there's that argument with admissibility as well, to say which can be even to refer to this case. When I was saying which was yeah.
Because briefly what happened to Wuti, who witnessed, who saw the incident happening. When a trial goes on, why is it free? And then the investigating officer obtained a statement who Google witness law came to court to testify which why witness and testify. The problem I court the case based on merits. We base on principle, which is incorrect, because if you quote the case, you must say why I'm a factor corner I have and allow. Because the principle yellow case cover voting, the evidence your mundo also feel there was moved in terms of Section 3 by the court. Testify. But there was second leg in that case as well of the identity. That is why judge Uyobon Bad is to write on a minority judgment in terms of the identity. Even Hello?
Uyaphileka.
Ngiyaphila baba.
Okay. Uthi ummangalelwa funeke azazi uba uphendula eliphi icala. Like which case is he answering? And kodwa apha we've got a robbery gone wrong, and then we've got a hit or assassination or something like that. So which is which?
Yeah.
Are those guys baphendula i-robbery gone wrong or baphendula icala lezinkabi?
I'm also confused on that one.
Out of 5 counts. There are 5 counts.
It will depend on what indictment says, because when the indictment will tell you exactly what are the allegations against you. Whether if robbery goes wrong, it will talk of robbery goes wrong. If it talks of Zingab, it will talk of substantial facts containing on the indictment.
Actually, there is murder. Count 1, count 2 is attempted murder. Then count 3 is robbery. Count 4 is possession of illegal ammunition, I think. Count 5
Yes, but what I'm saying is substantial facts, summary of the facts. As of jail, imeda yenziwa kwakwenzakalani, wawuhayarishwe ukuthi uhamba umbulala nohayarishwe ubani, or you went there to rob. Why you shot somebody? So I don't have the indictment. I can't actually clear what is the case against the accused.
No indictment yona ikhona. Ngasendele uMashika ivideo ngazumbe uyibona. Where ubalo read indictment. I think it was 18 July 2023 when the trial commenced. I think that's the first thing that they read.
Yes.
Before letting any witness.
Yeah.
Because it was just before that started. Witness one.
Yeah.
So before that, they know Ubalo read indictment. I was just looking at it. It's
a summary of the facts. It's
summary of the facts.
whether they were
contract killing. Robbery control.
Oh, okay.
So contract killing then comes when Keninda testifies. We discovered it was actually a contract killing when we eventually found the evidence that he communicating with the accused. But then clearly is a victim in this case. So she's both a mastermind and the victim. Now,
in terms of evidence, very difficult, as I say. I can only be sure of illegal principle. The evidence, I don't know. I don't know about evidence.
Yeah.
Ngicela ukubuza mina Fihlama sen. Ndithanda eligama you just use legal principle. Ithini legal principle when it comes to the state comes and gives their evidence, ne? And then there are witnesses that get called by the state, and then those witnesses, for instance, in a case of what Incredible just mentioned now, of the calls of Kelly Kumalo and accused number 5, the so-called calls. So via Vodacom now, there was a discovery that actually there were no such calls because they are not there at Vodacom. What does the legal principle say when it comes to Baloy now keep on talking about them as if it's existing calls, even though Vodacom, which is where evidence that put a stop to whatever when it comes to that evidence. But he still continues as if that's the thing in Dabaye's calls, but we already know there were no such calls.
No, in fact, if because depends on the judge. The judge must make a ruling if objection. But apparently, I don't think there was an objection from the defense to say he must not address on this because he position yakona in Wanji. Or Ubaloy is entitled to address on that, and then the defense can also address on that. The reply to say no, but in position level, it says there was no call, there was no call at all, or there's still a confusion there.
No, the issue of AMA calls is what I was saying earlier. At first, Stein, when he presented to Exhibit 011 for 2023, AMA calls now, they were MTCs, which means they are normal calls at 78 time. And then when Upinki came last year with the E205 Ivotako, then the state was caught. Now, Exhibit 01 last year was proved to be wrong, was proven wrong. Yeah, because those calls were actually by Oada and Hussein. If you go to the 205 at that time,
yes, I get you incredible. What I'm saying is, state is entitled to address with anything that they feel proves their case. It's up to the defense also to make their submission to say no, that is not the position. It doesn't prove your case, or that particular evidence should be kicked out, or whatever the case may be.
Yeah, then I was just putting in the picture. After the state was caught, then they amend the macros Dawana to say no, these were actually data calls which cannot be seen by protocol.
No, I see.
Yeah. So they bring in our downloads about the data calls, but that evidence was highly contentious. Mogustain was a very bad witness. Number WhatsApp calls and so on. So then, as we are saying, which Urata is the one who is going to decide. Maybe Urata believes to stay.
Sister way. Sure. I think umsindo wehlile manje because I believe bekunomsindo. This part yokuthi the police will take a docket to NPA. And the NPA give a correction to no, let us figure it not say this is not the charges, these are the charges that we're supposed to make. Let's say you take the police will make it a murder to the NPA, and the NPA say no, this is a premeditated murder.
Yeah.
Like different charges than the initial one.
Yeah, in fact, the police are not deciding on my charges.
Okay.
Police are collecting evidence to NPA. NPA decides what charges are they putting.
Then going forward, if there was a planning of killing, if there was a planning to unalive someone here, does not think this was a premeditated something on full 70 Salagam.
Conspiracy.
Yeah? No, premeditated, unalive.
Premeditated.
Yeah, so if kwakune planning ayenzekileyo apha, so bekungamele ukuthi kunjalo.
Bekumele ukuthi all
if there was a planning involved.
Yes.
Correct. Not if there was a planning involved, ukwenza lo msebenzi ezinye kwenza lo msebenzi
Yo, sorry guys, I have to go somewhere now. I will see you when I do videos now, because they are coming back only on Tuesday. There was someone that asked when they are coming back. Urata is coming back on Tuesday to give you judgment. Yeah. So I'll see you during the lives. I will always come through if these people go live. Because I guess you guys are enjoying this. And then I will do videos also. Thank you guys. It was nice. But I need to go now.